How did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
What happens when a government official files a trademark for an organization that doesn't even exist yet, waives the fee, and then approves it? That's exactly what unfolded in this explosive hearing, and the questions being raised should concern every American who cares about fairness and transparency. Before we break this down, make sure you hit that like button, subscribe to the channel, and stay informed, because this is the kind of story the mainstream media won't fully explain.
Committee has read all 2,800 and can opine on what he saw as the ratio. Recognize the gentleman from Maryland.
Mr. Chairman, thank you. Director Squires, how did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it
Please.
and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the president's speech announcing it, registered the domain name. And so
is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 U.S.C. Section 3, it's my responsibility to advise the President through the Secretary of Commerce on matters of national security and all matters of intellectual property. So
the Board of Peace is a public entity? It's a governmental organization, even though Congress has not created it? Is that right?
Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the president call you about the cyber squatting incident?
No, the president did not call me. It came up through several organizations about the cyber squatting, and the action needed to be taken to address
When you talked
the harm.
about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, Peace Committee, World Peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, a reference was made to Shakedown. This was registered, this particular boardofpeace.org, and without that, you don't have the
You
ability.
registered that?
No.
Oh, who
A cyber squatter did. I mean, 8 minutes into the
But
president's
you don't
speech.
have to talk about a cyber squatter. There are dozens of other groups that have peace in their name, right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 U.S.C. 3 and 35 U.S.C. 2 under the Lanham Act and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark, and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 U.S.C. Section 3 to advise the president on matters of national security.
So this is a matter of national security?
So here's what happened. During a congressional hearing, Congressman Jamie Raskin pressed a federal official over his decision to file trademark applications for something called the Board of Peace. Now, right away, things get strange. The official admits the organization wasn't even fully formed yet. Let that sink in. We're talking about a trademark being filed for an entity that may not legally exist. His justification: he says it was to stop cyber squatting, basically someone grabbing the domain name quickly after the idea was announced. And look, protecting intellectual property is important. No argument there. But here's where things start to fall apart. Raskin asks the obvious question: in what capacity were you acting? The official says he wasn't a lawyer for the group. He wasn't representing them directly. Instead, he claims he was acting as a custodian under federal authority tied to national security and intellectual property law. Now pause right there. Since when does the government step in as a custodian for a private or not yet formed entity's trademark? That's not something everyday Americans get access to. And Raskin pushes on exactly that point, asking whether regular citizens would receive the same treatment. The answer? Not exactly. The official keeps circling back to his role advising the president on intellectual property and national security. But that raises an even bigger issue. Are we looking at a system where connections determine access? Then comes what might be the most troubling part of the entire exchange: the trademark fee.
Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
The website says $350, is that right?
Generally, yes.
It's not expensive, okay. And my, one of the able lawyers on my staff just passed me this, you filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay,
but I do believe it's in
your
my authority.
Signature,
Yeah.
okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
yes.
Why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and then
by someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the trademark office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 U.S.C.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman.
We're talking about roughly $350. Not a massive amount, especially for something tied to what's being described as an international organization, but the official requested a fee waiver, and it was approved almost immediately. And here's the kicker. His signature appears on both the request and the process tied to the approval. That's where the conflict of interest alarm bells start ringing. Even if procedures were technically followed, this creates the appearance of insiders operating under a completely different set of rules. And in a country built on equal treatment under the law, that matters. Now let's be clear. No one is saying intellectual property protection isn't important. It absolutely is. But when government officials appear to blur the lines between public duty and selective action, it undermines trust. It raises serious questions. Who gets special access? Who gets expedited treatment? And who gets left behind? At the end of the day, this hearing wasn't just about trademarks. It was about accountability. It was about whether the same rules apply to everyone or whether power quietly changes how the system works. And that's something every American, left or right, should be paying attention to. Now I want to hear from you. Do you think this was a justified move to protect against cyber squatting, or does this look like a clear conflict of interest? Drop your thoughts in the comments below. This is a conversation worth having. If you found this breakdown helpful, make sure you like this video, subscribe to the channel, and turn on notifications so you don't miss what's coming next, because we're going to keep exposing, analyzing, and breaking down the stories that matter most. And trust me, you're not going to want to miss the next one.